My name is Dylan Gibbs. I'm one of the co-presidents of the Law and Business Association, and I will be moderating our first panel. I'd like to jump in with just a brief introduction of our amazing speakers here. To my immediate left is Keith Wilson. He is the President and General Counsel for Veritas Litigation Support, running out of St. Albert here in Alberta. He is also maintains a litigation practice as well. So Keith is an Alberta lawyer. He deals with cases involving land, the environment, expropriation, and compensation. In 2014, he started using aerial drone footage to present evidence before municipal, provincial compensation, and regulatory boards. After being approached by other lawyers and asking how they could use the same sort of evidence, Keith saw a need. He started Veritas Litigation Support in 2016 and now provides digital demonstrative evidence aids to lawyers and expert witnesses, including HD drone videos, 3D models, and computer animations. Veritas has been retained by local and national law firms, and the Veritas evidence techniques are now widely accepted before Alberta's regulatory boards and courts. As Keith says, paper is over 1,800 years old. Your litigation and advocacy techniques should not be. To his left is Mike Macaulay. He's a partner out of Lawson, Lundell. He works out of the Vancouver office primarily, but is also spending an increasing amount of time in the firm's new Kelowna office. Mike practices primarily in the areas of mergers and acquisitions, corporate finance, securities, private equity, venture capital transactions. He has extensive experience working with entrepreneurs, emerging companies, and venture capital funds in the technology, digital media, clean technology, and life sciences sectors. Mike is also a director of Accelerate Okanagan, whose mission is to give new and growing technology-driven businesses the mentorship, connections, and community they need to thrive. He's also recognized by best lawyers in the area of technology law. Finally, last but not least, we have Kate Simpson, who is the National Director of Knowledge Management out of Bennett Jones, Toronto. She's responsible for developing the knowledge management strategy and initiatives at Bennett Jones. She leads a team of knowledge management specialists in delivering innovative practice tools and resources that leverage the firm's intellectual capital. Prior to Bennett Jones, Kate advised many other Canadian, UK, and global law firms on the design and implementation of useful and engaging knowledge management solutions benefiting both lawyers and their clients. She recently authored an article for the Canadian Lawyer magazine titled Disrupting from Within. This article discusses the function of strategic partnerships as drivers of law firm innovation and the concept of entrepreneurship. So with that, I'll turn it over to Keith. Each speaker is just going to go through a 10-minute presentation here about their link to innovation, and then we'll hop into a moderated discussion and leave some time for open Q&A from the audience.
Thanks, everyone. My name is Keith Wilson. As you know, I've been practicing litigation for 23 years now. And a lot of the cases that I deal with a lot of environmental litigation, usually, well, always representing the little guy, not the big guy. They have lots of lawyers to represent them. Land development cases, water law, lots of things involving landscapes and the environment, construction disputes, commercial litigation. Lots of regulatory work as well before most of the regulatory boards in the province. And one of the things that I found being a lawyer, and it's interesting, you go into, if you have a trial in the Court of Queen's Bench, and the subject matter that's at the center of the dispute is something that exists in the real world, how that which exists in the real world is brought before the judge is through stacks of paper. In other words, we use the oral word and the written word to create pictures in the mind of the judge. And when I talk to other senior counsel, we've all had the experience, whether it's a hearing or a trial, and we read the decision, and at some point as the judge or the decision maker or the regulatory panel is describing the facts, you go, they didn't get it. They get some critical piece wrong. And there's some lawyers in this room that are nodding their head right now. And you just kick yourself. And I don't fault the decision maker. It's my job as counsel, as the advocate, to make sure that the decision maker gets the right picture. So what do we do right now in our day-to-day lives if we want to figure something out? The dishwasher's plugged. Do we read the manual or do we go to YouTube, right? I don't know how many things I've fixed and been a hero to my wife because of YouTube. Some other guy said, yeah, all you got to do is this. And you go, oh my God, that was easy. So, but back to the courts. What do? We show up with paper. So I got frustrated. What drove me to that wasn't that observation. What drove me to start using these technologies was it didn't matter how experienced my expert was. It didn't matter how sophisticated my witness was or unsophisticated. Did not matter how many days, weeks, or months I would spend in preparing them. You put them up on the stand. Most witnesses do not sleep the night before trial, or they don't sleep well. They're stressed to the max. And you ask them questions. You know they know the answer, and they don't give it. And you sit there and you go, how can I win this case when my witnesses fail on me? And it's a common problem where your witness it's a tough thing to stand in the Court of Queen's Bench, because you don't sit, you stand in the witness box, and it's equally difficult to sit in a hearing room. So it occurred to me that if I could take the facts to the judge and put them in front of him or her or the panel in a regulatory matter where they could see for themselves. And then it didn't matter whether my witness had a malfunction on the stand. It would be there. And then the other advantages I realized was it's something that you can use when you bring these demonstrative evidence aids. And the law of evidence regarding what I'm going to show you is well established. The Supreme Court of Canada has ruled on what's admissible and the admissibility standards with respect to demonstrative evidence, and when you transition from real evidence to demonstrative evidence, and that's all there. What's new is the technology that I've started using and other law firms are using. Just maybe start rolling. So this is a bit of what you're going to see on the screen here is just sort of a montage of different techniques that we use. So one of the things that we do is we'll fly a drone over the landscape. One of the problems we run into is the technology, display technology, and everywhere we go is not very good. Can we bring the lights down just a little bit more so people can see the screen? Is that possible? That's much better. Thank you. So with the drone, we have drones that film in 4K, 6K, and 8K. That means that we can zoom in we can take a screenshot and zoom right in, and there's no pixelation. So there's no such thing as not getting the shot. A lot of these are not evidence videos because the evidence videos are usually confidential, and we're very strict on respecting that. There's a few that are public that are little snippets that are shown in here. But what we do is we take the drone video and then we can enhance it with annotations. So we can label things. This was a case that went before the AUC and the Utilities Commission. The issue was what's the best place to put this massive transmission line. Similarly, this is another case where that was used. And when you use this in the hearing room, the experts are able to pause and explain things. The landowners or the lay witnesses are able to do the same. What's really been interesting is in regulatory hearings that I've done and others have done, the panel themselves, the commissioners, will stop the video and say, explain to me where this is, or explain to me where that is. It allows a decision maker to contextualize, to understand, to better receive the rest of the evidence that comes in. We can also do really sophisticated, we're using these animated motion maps a lot more. I'm going to show you a case that just went to hearing just before Christmas involving sour gas wells out at Drayton Valley that's public that I'm allowed to use to show you. But it allows a huge amount of complex information to be conveyed in a way that's very simple, easy to understand, forms part of the record so that if there's an appeal or judicial review, the appellate body gets to see it. and so on. These are visualizations where you can actually insert something into the landscape. Again, these are some of the commercial things that the sister company Smart Drones has done, but we can do the equivalent thing in the context of litigation files. Now, the drones also collect a huge amount of data, millions of data points. Drones are being used now in archaeological work because they're so precise, and we can, if there's an accident scene, an industrial failure, a construction dispute, we can fly it, we can preserve the evidence, we can create a 3D model that you can actually fly through. The data is so rich that the 3D model actually looks like a video. That's not a video, that's actually data. What's significant about it is if you take a picture, of me, this camera that's filming me right now in the middle of the room, it doesn't know what I can see on my side of this piece of paper. But if it's a 3D model, you can come around behind me and see what's on this page. So another interesting thing about litigation, the more you do it, is when you take on a case, you don't know what you don't know. And often it's not until you get into trial that you realize you thought the issue was over here, and it turns out it was behind you. So the beauty of going out and preserving evidence, doing 3D models, doing the flyover with the drone, is we collect everything, we preserve it. You can have a situation where your expert just before trial realizes that they haven't taken a proper measurement when they're going over their report. If it's 2 years after the event, if it's a bridge failure or something, doesn't matter because we have the 3D model. They can go take the measurement at any time. And the other thing that we do is computer animations. Some of the subject matter that we're dealing with in hearings and before courts is incredibly complex. Hayden, just bring up the start of the Drayton Valley. So it's incredibly complex. You know, patent infringement cases, dealing with circuit boards and other things. So you got a judge that may have no experience in the subject matter, and you as counsel have to get him or her to understand this incredibly complex matter. Medical malpractice. Not a lot of judges are former doctors. You have to get them to understand the science, why some procedure was done wrong. So demonstrative evidence aids can help decision makers better understand highly technical evidence. As lawyers, we've been very reluctant to embrace the technology. Instead, we've been using what this case was about. Did the circle pop up yet?
Not yet.
Okay, so all these residents here are trapped by the river on the one side. Critical level sour gas wells. This is, thank you, that was my 10-minute warning. I'm up, I'll go 30 seconds. So this is the distance and the time rate at which the sour gas, the H2S, would move at a concentration of 100 parts per million, which you won't get many breaths in. You'll be dead. So one of the issues they wanted us to help the decision maker understand is that if there was an event at that well, all those residents would have to drive back through the plume to escape. This is a 10 part per million exposure, and you'll see how far it will go. These are 3 clustered, very, very high concentration sour gas wells. So an expert at the hearing, we based this on his expert's report. We developed this, and then he spoke to it at the hearing to allow the decision makers to understand exactly what we're talking about in terms of rate of spread. So Veritas Litigation supports about bringing modern visual digital technologies, making them available to lawyers to help them manage litigation risk, be more effective in their cases. And my ultimate goal is to hope that things get settled more easily so we don't have long, expensive litigation. Thank you.
Okay, thanks, Keith. We'll turn it over to Mike now for his 10-minute presentation.
Sure, thanks very much. I don't have a slideshow, so I'm just going to stay seated if that's all right with everybody. Generally, I'm going to speak a little bit today mainly about my experiences with innovation in the practice of law. As Dylan mentioned, my practice is primarily focused on working with companies in the innovation sector, often startups and emerging companies. These companies, are the ones you read about in the paper that are out there looking to, break existing models in various lines of business, and they take the same approach often to working with the professionals they're working with, and so often they're at the front lines of pushing our firm to adopt innovative methods, not just necessarily technological solutions, but also other innovations in the way we deal with clients. The old ways of doing things often just aren't good enough for these entrepreneurs. And so I find myself constantly having to adapt and change the way that I approach my practice, and encourage those who are working with me on my team to do the same, and often I'm sort of bringing these things up with firm management and trying to get larger changes made. So in terms of my experience with that, I think there's two pieces of this, as I alluded to. Part of it is technological adoption by law firms, and what trends I see on that. The second piece is sort of what non-technical changes and innovations I've been making in my practice, and things that I see that are happening in law, and just different ways of thinking about things. So I'll speak a little bit first to the technology adoption side of things. This is one often, I sort of have various intersections with this in my practice. Often it's from technology companies that are creating solutions for law firms. They've worked with law firms. They say, "Wow, this is a broken system. I think this can be better," and we've come up with some solutions. So some of these are led by former lawyers. Some of them are not. So the range of services and solutions that they offer, is fairly broad. Often on that side of things, also there's investors that I deal with who will bring me, deals that they're looking at and saying, we've got this company that produces software for law firms. It's aimed at the legal market. Can you have a look at what they're doing and let us know if you think there really is a market for this? It looks interesting. The technology's sound, but will lawyers actually use this? So in those cases, often I'm talking to the clients and talking to them about the business model and how they are approaching law firms, and whether or not, despite the fact they've got slick technology, is there market? Is there any adoption? And there's, as many of you will know, there's a lot of challenges to getting technical solutions adopted in law firms. It's you need to get a lot of buy-in from a lot of stakeholders, and often in law firms, lawyers, just despite the partnership being a business, a lot of lawyers operate fairly independently, and changing their behavior can be a challenge. Getting buy-in to broad technological adoption, it can be a challenge, and just getting technology in at scale that makes sense. So often pricing models I see people coming with just frankly don't make sense, because they're approaching a law firm as a large enterprise, going, well, there's 700 lawyers here, this is what we should be charging, not realizing that there's maybe 20 lawyers there that realistically are going to use their solution, that have a niche practice where that really will solve a problem they've got. Other challenges I see there are often the technical solutions that are being brought. There isn't a business case for it from the law firm's perspective, unless it's sort of solving, an efficiency problem. Certainly for large law firms, unless it's something where there's lawyers really going, I need this because it's going to make my practice more efficient or help me in my day-to-day business. Often it's a hard sell, unless there's client pressure specifically speaking to, you need to adopt this because we're adopting these types of procedures in our practice. I mean, a classic example of this was, you look at the slow rate of adoption of electronic signatures. This is something lawyers do every single day, collect signatures from clients, and you would think at a basic level we would have been very, very quick to adopt a technical solution to collecting signatures easily and more efficiently. It has taken years for that to gain just acceptance. Even in the last 2-3 years, I've had partners of mine ask, is this, have you worked with this company? Is this a valid signature? Is it good for this purpose? These sorts of questions. People don't like to change, even when it can make their life easier, if it means that they've got to spend time sort of investigating it. So things where I see it making a lot of sense, obviously things like what Keith has, where it's solving real problems that will help individual lawyers in what they're doing day to day to be better lawyers and perform better for their clients and satisfy them. I think that those types of things, I think, get much quicker adoption and because the business case is there. So that's on the technical adoption side of things. Part of what I'm seeing. The other piece of it is clients, both within Canada and the U.S., as well as investors who often will approach us saying, can you adopt this technology? We're using this, or our firm in the U.S. that we use is using this software. We want you to start using this, or speaking with firms in the States where this sort of pressure. I find they tend to be years ahead of us on a lot of these things. So in talking to other lawyers practicing in my space on the other side of the border, you get a bit of a glimpse of the future sometimes as to what may be coming here. I find it fascinating still that the same challenges, continue to exist there, even in firms very focused on technology. A good example is right now there's lots of pressure from, again, emerging companies and some of these startups to adopt electronic, share register management that will help them produce their cap tables for their investment rounds in one piece of software. Seems great from the client perspective, lots of efficiencies. You bring that within the law firm and the paralegals tend to struggle with it. It creates more inefficiencies, and in the end, something that seems like it should be more efficient ends up costing the client more, and with paralegals spending more time figuring out new software. So, those sorts of challenges are always there. The other piece of the innovation coin, or other side of the innovation coin, is sort of the day-to-day changes that individual lawyers can make and that the firms can make in terms of how we approach our marketing, dealing with clients, and files generally. And so this is something, again, where I find in my practice the clients are demanding that we change the way that we deal with them. They're looking for greater cost certainty, more efficiency, and increasingly sort of wanting us to come to them. So changes that I've made and that I see a lot of pressure on to change is moving more and more to fixed fee billing arrangements for certain sorts of tasks that are becoming more and more commoditized. You see this with startups often. We do startup packages to sort of help get them off the ground where there's a great deal of cost certainty for what they're doing to get them to a certain point. I know a lot of firms are doing similar sorts of things. Again, that's from that pressure from this group looking for that efficiency. Other things are, new ways of approaching the practice of law. I think it's not good enough anymore to sort of sit there and rely on old referral networks or rely on legacy clients to continue to drive the business. You've got to sort of adapt and be a bit more nimble. On that point, we've sort of recently, as Dylan alluded to, opened up an office in Kelowna that I've been very involved with, where we're sort of taking a bit of a different approach. It's sort of a technology-focused office that we've opened up, and we'll be sort of opening the permanent space within the new innovation center there in Kelowna. So we're going to be fairly integrated with some of the tech incubators that are in the community there and in the building. So just a different approach to how we're working with the community, working with clients, and sort of engaging. So I think there's lots of room to innovate in the way that law firms approach things. It's not just the bricks and mortar model. We've got people that are, fairly mobile, that are working in and out of that office, passing through, working still in Calgary, working in Vancouver, doing work remotely from that office in order to sort of bring those technical skills, to a different location.
Great. So thanks for that, Mike, and over to Kate.
So I obviously need to take a few lessons in how to prepare for conferences like this. It'd be much better to be able to just wing it. That was brilliant. No notes. He had no notes. Mine, I have full notes. So sorry if I'm very different. The way I approached this was trying to figure out how I stay sane, trying to introduce tech to lawyers. I had many of these. So I know we're all really, really busy people, and I know we have no time to actually innovate, but I wanted to just say thank you for coming today, and indeed for inviting me. As we know, software is eating the world. This is Mark Andreessen. I don't know whether you follow him as an entrepreneur and an investor to follow. He wrote this in the Wall Street Journal so many years ago, and it's absolutely true. Software is eating every industry, as we've seen. Many commentators write about the taxi industry and hospitality. Software is eating literally every industry, and legal is one of them. But I want to talk about the truth about robots, and the truth really is that they are not robots. They are little algorithms, basically. But I really like this cute picture. He's just so cute. I'd like him on my desk. So for big law, I suppose, there are two types of innovation that we deal with. There's the efficiency side of innovation. It's not really innovation, it's just a new way of doing things. But it's about reducing costs, whether that's client costs or internal costs. And the second one is the innovative client solutions. They're the really exciting AI, machine learning, and that's about chasing new clients and chasing new markets and creating ultimately new revenue. What I've found so far is that you can't do the latter without doing the former first. You have to free up lawyers to do. I will get this right. If you free up the efficient lawyers, you can actually get them to look at new revenue streams. But they're so busy, they're too busy focusing on getting the work out the door that they can't focus on reimagining the way that they practice. So in my world, I think there are going to be very few occupations that will be actually automated in law, but I think there will be certain activities that will be automated, but they're not going to replace us, and I need to make that very clear. But efficient lawyers will allow law firms to do more law ultimately, and I think that's pretty much the exciting stuff. That's why I'm hanging on to my job, because once efficient lawyers realise that there's more law out there to do in a better and more exciting way, we get to optimise AI. It's one of the most exciting times to be in law. So I'm waiting around until they catch up, and then we can figure out the new business lines and how we can be more economical and productive. So tech innovation in legal. So I'm going to run through where we kind of see this happening, Bennett Jones and other law firms. I reckon it's these three areas are really where we're at right now. These are where I see three areas that computers are simply just better. They're smarter, faster, and better, and therefore cheaper than humans at performing. And so I'm going to deal with each of those. The first is discovery, review, and research. And yes, I know that those are three things, but I like the number three, so bear with me. But I've lumped them together because basically all of these companies solve a single problem, but they just solve it in a different way. And that problem is TMI. It's just too much information. The problem, our e-discovery, review, and research tools are just helping us filter out the massive floods of information that we have. There's e-discovery, where we think that we can review as effectively as a computer the sheer amount of gigabytes that are there. If you printed out just 1 gigabyte of email, it would be 110,000 pages. There is no way on earth a human can do that as well as a computer. And I can't believe that we still pretend that humans are better than computers at doing some of this review work. We should be allowing, I do like this, we should be allowing the computers to churn through and separate the wheat from the chaff. That is the best thing that computers do for us. They can figure out what's relevant and what's irrelevant, so that humans can and lawyers can focus on the valuable stuff, the high value stuff, rather than the low value stuff. There's no point trying to take all of the irrelevant and expect to come out with the same outcomes and the same analysis. The same is true for case law. No one person can hold all of the case law in their head. They can't hold a whole library in their head. That's why we have computers, and we should be joyful at that. We should let the computers filter out the crap, the chaff, so that we can just focus on the relevant. And then it's getting, and legal research doesn't stop. It just keeps getting more disruptive. And again, they are not robots, it's just an algorithm. But you still have to read the cases, but you don't have to read all of them, and you don't have to know all of them. You can rely on the computer to tell you what is relevant, if you can train the robot. The thing is that the algorithms are not great out of the box. It's just like having a student join your firm. You have to teach it, and you have to continue to train it. And I'm not going to talk any more about ROS because we have, I'm sure, lots to hear about them this afternoon. So the second major innovation that we're seeing is workflow automation, and by this I don't mean practice management platforms. I don't mean Clio. I don't mean the billing platforms that we use. What I'm talking about here is more optimizing the processes that, and sometimes it's business process optimization rather than legal process optimization. But there is a huge number of inefficient processes happening at law firms, both within on the business side and externally with clients, that need to be optimized, that need to be automated. So patents, trademarks, some commodity litigation work, these things require computers to help us get from A to Z. And I think this is where we're seeing the adoption, which I'm about to go on to. This is where I find the most rejection of a lot of the innovation that we're seeing. So examples are the fact that we apparently get high-value lawyers to be copying and pasting from one Word document to fussy word tables in another document. And computers can streamline this. They can do it. They can actually do it far faster. And then you as a human are the check. 2 minutes already. Oh no! I'm going to have to talk really, really fast. Who remembers the days when? Very few, but when you walk past to an office with students in it, and they're reading out agreements to each other to figure out where the black line, where the gaps are. Like this is how archaic to me copying and pasting from one Word document to another is. And closings, I can't understand why people are still printing boxes and boxes and boxes of papers to get their transaction in order and their signature packages together. I think the rule that I have is that if you think that there has to be a better way, there usually is, and it's a computer that's going to do it for you. So you should stop doing whatever it is. God, I'm only on 3. I practiced this and everything. It was definitely 10 minutes. The final thing is gut feel. So this is one of the more exciting ones where you really see some of the artificial intelligence and the machine learning coming out, where they're taking massive amounts of data and being able to predict outcomes. And I think this is where I'm buying a lot of this for my firm because I'm excited by it. But as Ed Walters from Fastcase says, data will ultimately have your hunch for lunch. Lawyers are expected to predict outcomes for clients all the time, but that humans have such biases, such cognitive biases, that they can't distinguish the outliers from the norm. And computers and algorithms who base some of these outcomes on data will be able to give you the norm, and then from there you can then predict how a single case might be. And I have an example from I don't know whether anyone does Fantasy SCOTUS. Anyone heard of it? It's fabulous. So they pit algorithms against crowdsourcing, and the results quite blurry, can't see it, but trust me, the middle one, which is just the algorithm alone, still gets stuff wrong, and that's the thing we have to remember. It's actually the crowd prediction on top of the algorithms that we're working with, and that's what they're proving every day when on Fantasy SCOTUS. So this was the main part of my talk, which is about the frustrations with buy-in, adoption, getting lawyers to actually use the technology that we have. But change is hard. Humans are basically lazy and like to make stuff easier all the time and take the path of least resistance. So we have to expect that lawyers themselves are also going to struggle with some of this. But there's urgency. There's so much tech and so much innovation happening. And on the business side of most law firms, we're all urgent, but it's taking the lawyers a little bit longer. This was interesting, but we'll move on. So change is hard. Kotter's 8 step. He has 8 steps for change management. Do we follow any of these? I think we're trying to. Innovation and change takes a framework, a culture of change, if you like. I saw this yesterday. This is law firms who are actually creating innovation teams and leaders in their firms. It's getting. Bennett Jones isn't on there, but we have innovation also. But that is what sets the culture for change. We need these innovators to actually create the innovative places for our lawyers to, from an osmosis thing. I don't know whether you've all heard about the chasm. That's the biggest problem with innovation. Is in our firms we do have examples of innovators and early adopters. They are your champions to cross that chasm and reach the early majority to actually make an effect and more widespread adoption of some of our tech. And so what we need to learn is what is it that takes that step across, and there are lots and lots of reasons to do it. Read this book, just switch. They have a whole bunch of reasons of how to get people to just make a switch. You have to direct the rider, motivate the elephant, which is the emotional side, and shape the path. And you get those 3 in alignment, and apparently, boom, we've all switched. Haven't achieved it myself, but I'm still working on it because it's complicated. It's like 9 things you have to do. Other things I've learned, that the product has to be simpler, better, faster, cheaper. There has to be a really good benefit for someone to actually adopt that thing. It has to be useful, usable, and engaging. If it isn't, like, get off the path. It has to be embedded into the lawyer workflow. What we forget is that lawyers follow a workflow every single day, and they are focused to get to the end of that workflow. The moment you introduce another system, another tool that they have to remember to open, muscle memory goes out the window and they struggle. So much better to actually embed it into the lawyer workflow. The rule of 7, which is nicked from the sales and marketing dudes, they say that a prospect has to be in some way touched 7 times before they will, in any way, shape or form, respond to your advert, to your... That's what it takes for awareness, 7. So that's why we keep repeating things over and over again to lawyers. Autonomy, Mastery and Purpose, that's another great book to read, Daniel Pink's Drive. That's what motivates us, the autonomy, mastery and purpose. The moment that we try and play with that in a lawyer's world is the moment that we lose their support. Champions, you need your champions. That for me is the 15%, your innovators and fast followers. You need board level support. Nudge Theory, another great book to read, but making it more difficult to do it the old way. We have to find more difficult ways to do it the old way. We have to just nudge them into the behaviour that we want. And you have to just constantly go on about what's in it for that person. Your empathy for individual lawyers, not whole practice groups, is essential. And that's me.
All right, thank you, Kate, for powering through the last bit of that. A lot of information there, and I think that ties well into some of the moderated discussion I'd like to get into before we open it up to questions from the audience. So I think everyone sort of touched on this external versus internal pressure, and it sounds like right now we're still at a stage where a lot of innovation from law firms and lawyers is coming from this external pressure. If you're not having clients basically forcing you to adopt these solutions, then it's not happening. So I'm wondering, I mean, we saw Kate's numbers up there, 73% of firms adopting innovation positions, which seems great. I'm wondering if just from your taste test or feeling out there, if there is a sense that these internal cultures are changing, that lawyers actually want to innovate and recognize that we should be serving clients and innovating for that less so than ourselves.
Yeah, I think overall, I mean, I think a lot of lawyers like the idea of it. It's the putting it into practice, which I'm sure, Kate, you probably have more experience with that exact aspect. I mean, I'm sure lots of people will say that yes, we need to innovate. There's broad buy-in conceptually to it. I think it's when someone's then needs to implement it into their day-to-day practice that it tends to stumble a little bit, I find.
Yeah, I try not to generalise. Across my firm, I have to realise that my firm is made up of individual lawyers who have individual practices and individual priorities and goals, and clients who want to start talking about these things, and other clients that don't. And I, to stay sane, I work with the willing. There is no point trying to drag people kicking and screaming into whatever century it is, or even decade. It's much better to work with the willing and find that 15% in the firm and say, this is the cool new thing. Does this in any way affect or interest you in your practice? Do you need to redefine yourself, redefine the way that you find clients, how you build your practice? So I like to work and find those people first. It means that I get to have a laugh at work, which is the number one priority for me. And then the others will come and they'll figure it out and they'll be able to say yes or no, that is relevant for me. But I don't need to bring my entire firm with me. People can stay wherever they like.
So then I guess for Keith, are you feeling like in response to the technologies you're presenting that there is, it sounds like you've had good feedback and the courts are accepting it and other lawyers are approaching you about using it. Do you feel like this is something that people are willing to uptake very rapidly and maybe expand into other types of advocacy techniques that are moving in an innovative direction?
Well, the biggest persuader has been being on the wrong side of the evidence, and it causes counsel to say, next time I have a case like that, and I get calls from lawyers, and I had one not long ago, and we were getting early into it, and he said, Wilson, are you going to bring that drone thing? And I said, you betcha. And he said, all right, I'll get a settlement proposal to you. And I mean, I oversimplify it, but it's true. A lot of, there's a well-known judge on our Court of Appeal, who I won't name, and I had practiced with him before he was there, and I said to him, what's it like being up on the court? And I won't use his exact language, but he said, you're sitting up there, and both sides are bullshitting you, and you've got to try and figure out who's telling the truth and what's going on. So all that we're trying to do is shine the light on things and remove some of the complexity. If there's too much information, there's an opportunity to obfuscate. But I think the theme of the question, when you're a lawyer, we're supposed to, whether you're a corporate lawyer and you're drafting agreements, we're supposed to anticipate every possible thing that can go wrong. We're supposed to be, future tellers and cynical about all the bad things that can happen, right? Because when the relationship does sour between the business partners or the supplier doesn't do something, it'll seem obvious, like, well, how come you didn't put a clause in the agreement for that? Litigation, I could give a parallel analysis for litigation. What I'm getting at is, as lawyers, we're always dealing with risk. And so once we start to figure out how to handle a particular subject matter file and we get a routine for it, trying to break us out of that is risk. And so it takes a lot of, and Kate's presentation was awesome for helping shine a light on the reasons, but I see that all the time, is the real reluctance to embrace technology. But just like email, I still remember some lawyers, older lawyers, I mean, I've been practicing for 23 years, and I've been an early adopter of technology, so I loved email. It was great. I mean, and so you get a lawyer and they're just like, yeah, this email thing, and it's a fad. I just say it's a fad. It's like bell bottoms. Don't even go for it. It's going to be out soon. It's like a pita cheddar or whatever that thing is, that pet rock. But of course, they weren't sure if I was joking. And then I loved it because they would take their handheld dictation machine, dictate an email response to my email, and give it to their secretary or their paralegal, who would then prepare the email, print it out, give it to him or her on a piece of paper. They would mark it up in red. Do you know what I've done in the meantime? I've sent them 3 emails. And of course now that's changed. So lawyers, the lawyers that thought they could get away without doing email, and I now get the 73-year-old lawyer, litigator, thumbing out on his phone a response to me, which is great, at 8 o'clock at night, which is fine. The file's moving forward. So eventually I think the technology can force them into the change.
Well, that's great. And I think, to some extent, having these conversations and looking around at the room and the range of ages we have in here, it's great to see the uptake just from the community. And Kate talked as well about, building positions and trying to build that culture that way. I'm wondering if there's anything else anyone on the panel thinks that we can be doing as lawyers and firms and as people interested in this space to prepare for this innovation-driven future. Aside from, waiting for our clients to tell us change has to happen, is there anything else we can do from inside?
Attend training sessions. Demos. Learn. The continuing professional development, I think, is a fascinating one. The lawyers are encouraged to continually develop their skills and their what they know and what they understand. And yet, I think they're also quite cynical about the fact that they have to do that, which I think is unfortunate because there's so much that firms put on, and I wish that they weren't so cynical. That they would go and actually be interested in what's changing outside of the walls, so that they know when their client asks, they don't look blankly at their client. That kind of terrifies me, because that's all I talk about. And the idea that a client goes to a partner and has and starts asking about some of the tools that we already have, and the partner not know that we already have them and they're already rolled out to some of their team, panics me. It's like, send them to me. I'll tell them all about it and how exciting it is. So I think just being curious, I suppose, would be my one wish.
I think more dialogue internally on what is out there and what is changing. I think for I see more of it in my practice than most of my partners, and I think for a lot of people, I don't think even understand what technological solutions might be out there. So I think there's room to have firms lead a bit more discussion around what's available and what are people interested in, and here's some here's some education around some of the technological solutions that we could be looking at. And, instead of keeping this on a closed committee of, 5 people who are the tech committee looking at it and trying to make an assessment for everybody whether this makes sense, let's educate everybody as to what's out there and see what people are actually interested in using, and let sort of individual lawyers guide the process a little bit. But, sitting around and waiting for individual lawyers to come with the solution themselves, I think is not going to work. You sort of need to feed them what's the opportunities a little bit.
I'd just add that, I've worked in a couple of really big firms, and before I made the decision to go small, the pressures are enormous. And I remember going to the monthly litigation meetings or the various other meetings we had to go to, or whether it was a morning sort of breakfast donuts meeting or whether it was a lunch meeting, is you sort of subconsciously say to yourself, don't these people realize I have important things to do? And because there's all the pressures on your time, the billable hours. If you're in litigation, you're in 24/7 combat, and your opponent's hoping you're actually at lunch and not at your desk. But at the end of the day, I mean, imagine if a firm said, we're going to eliminate email. I mean, you'd have a revolt. The lawyers, you can't take that away from me. So I think it's a tension between trying to overcome the day-to-day pressures that lawyers face and continually sort of force expose them and force feed them to the point where they start to take it up. And then I think you reach a sort of a pivot point or a tipping point where technology flips and we couldn't imagine doing things without it.
Well, that's good, and that's a great tie-in to my next question, which is that as we reach this inflection point or tipping point, or however you want to describe it, looking out at 10 years, what are the solutions that we're going to be forced to adopt? I mean, I think that the stuff you're doing is, some very easy wins for lawyers, and Kate as well pointed out some of the low-hanging fruit, and even Mike in terms of just billing solutions and how are we structuring our costs. But what in 10 years will we absolutely have to adopt or fail?
I can go first on that one. I think we just have to be more efficient. Legal fees, particularly litigation files, if you're in a file with a large firm, the rate of burn is unbelievable. It is absolutely unbelievable, especially when I see a file and there's a couple of wolf packs on there. They can chew through $100,000 in the snap of a finger. And the technology allows us to be more efficient. You look at the whole e-discovery thing and, the massive amount of data. So I think there's going to be a constant pressure for efficiency. I think and then the other factor I think that's really important is going to be competition, because some firms are going to get better at it. And then one client's going to have an experience, you have somebody's a CEO with one company, they have a long-standing relationship with X firm, and then they become a CEO of a different company who has a long-standing relationship with another firm. They get exposed to the more efficient techniques, or the new firm doesn't have the efficient techniques. I think competition will drive it.
I think AI is going to be a big one. I think at the end of the day, law firms are going to need to get on board with it in a bigger way, driven by efficiency, and I think it's exactly that. I think more and more there's more downward pressure on fees, clients looking for more competitive bidding on things, and firms are looking at various ways to try and get there and do work more efficiency, get more certainty around billing. Firms are looking at sort of non-technological solutions with sort of onshoring and insourcing and all of these things to lower cost centers even within the country. Moving due diligence functions to lower cost service providers. But at the end of the day, those models can work for larger firms. For mid-sized firms or smaller firms, they're not going to work, and AI is going to be sort of the big equalizer for a lot of those tasks. And I think ultimately that's where a lot of those pressures on efficiency are going to lead to.
I'm rubbish at predicting things, so I won't. But I do think the trend I kind of see right now is, as we were talking before we started, the law is a relationship business, and I think it still will be a relationship business, but I think there will be a distinction between the commodity work for low risk and low value versus the high value, high risk. I think we'll always need to hold the hands of our clients through their most stressful times, whether that's corporate or litigation. And I think, but there will be a definite divergent of the way we deliver legal services for the more commodity, low-value stuff, which I think is still relevant and exciting law to practice, and becoming a trusted advisor and sitting on boards and giving that 12-minute piece of advice that saves the company should not be done on a billable hour basis. You should be paid your entire annual salary for that 12 minutes. But to get to trusted advisor requires a lot of working at the coalface of the volume work, figuring out how companies work, what they actually need, where their risk profile is. I think quantifying risk is going to turn legal upside down over the coming years. The insurance industry has already changed so much of what it does based on the fact that it can quantify risk. And I think lawyers need to figure out how to quantify the risk that their clients are taking and advise based on that risk profile, and be a lot more understanding about how risk appetites actually change throughout a deal or a case.
That's great. So with 20 minutes left here on this panel, I did want to make sure we leave some time for audience questions. And we have a mic here that can go around. So do we have any questions out? Do you have anything that I want to ask the panel?
Check. Hi, non-lawyer here, so not familiar with how things really work internally with law firms, but so there was an alphabet soup of like different companies and tools I think that you could access there. It looks like it's probably a lot to negotiate. Potentially, if each one of these is a company that is like investing money, data processing, algorithms, this could be very expensive. And if this really does affect the potential for real outcomes, are we seeing kind of a further advantage to the rich here, where basically outcomes in law are going to more and more be determined by is it going to become like the pharmaceutical industry where you've got all these awesome tools, but can you afford them? Is that what this is turning into, I guess, is what I'm wondering.
I was thinking you were going to use the premiership as only the rich clubs get to the top of the premiership, but
yes.
The pharmaceutical also works. So, there is some to that. I mean, we haven't bought all of those. They're just, everything in the industry, not everything, obviously. There's some key missing ones, but I think some of this is opportunity cost, and I think you have to recognise that some of the investments that you make, especially in the early startups, may not work out well. But I'm allowed to take that risk for Bennett on behalf of Bennett Jones, or I think I am anyway. I have a team where we can test some of this stuff, and some of this stuff works, and some of this stuff doesn't so much, and it requires time. But most of them are priced quite fairly. It's based on usage, and so if your usage is low, then you don't pay as much. And I think negotiation, which lawyers are exceptionally good at, means that you can actually get your way. And some law firms have got it for, very rich law firms have got some of this stuff for free because they're the guinea pig. Because we are guinea pigs for some of these startups to figure out whether what these startups come to us with is scalable, whether it can be scaled for large firms. So I think there is a tiny bit of opportunity, but I think you have to be in it to win it. So you have to just try some of the cheaper versions of these things. I mean, there are very expensive e-discovery tools out there, and there are slightly cheaper ones that are as good as the others. So, but you need time to be able to horizon scan and find the perfect fit for your firm or your practice.
I'd just add that my experience in the 23 years of doing this has been that technology has in fact been an equalizer. I mean, until recently, most of my clients are, ordinary folks. As I started, when I left the big firm, there was a gap in terms of my capacity to provide the same level of advocacy and legal services than I could when I was in the big firm. But as each year goes by, that gap has closed. And because, for example, initially Quick Law was very expensive. Now for $340 a month, I have access to just an unbelievable, very functional database and secondary sources and means of collecting, storing, reproducing, incorporating into briefs technology. So my experience has been that rather than technology being a function of creating a divide, it's actually been an equalizer.
I was thinking you got a really good deal.
Yeah, so Quick Law started out about $150 a minute. When I stopped practicing, I was paying about $100 a month. And I was using the same law sources as Bennett Jones.
I'm phoning Quick Law this afternoon.
Me too.
Thank you. Very fascinating discussion. Michael, you mentioned that in your experience, the law profession in the U.S. is ahead of us in terms of its adoption of new technologies and whatnot. And I guess I wanted to probe into that a little bit more. And get into maybe some of the cultural barriers. I think we are kind of a more risk-averse culture perhaps than the U.S. And I think in Alberta, especially being such a kind of 20th century resource-driven economy, how much of a barrier do you think that is, and what needs to be done to kind of overcome some of our cultural resistance to this sort of thing?
Yeah, thanks. Yeah, and actually what I found with that is not so much that the adoption necessarily is quicker amongst sort of our U.S. counterparts. It actually sort of surprised me to see that it was actually quite similar, given that they were facing a lot more pressure, because I think their clients are pushing a lot harder on this. Given the scale and size of their market, there's just a lot more legal tech down there that hasn't even sort of found its way into Canada yet, because they haven't sort of bothered building in features to address Canadian law. So they're just inundated with these sorts of things. And so what I've found is they actually struggle with adoption as much as we do. They're still resistant to it, and it still is a huge challenge down there, the same as it is for us. So I think it's not necessarily, a Canada-U.S. cultural change on the risk. I think it's a cultural change at law firms in terms of how we approach and view technology and how we approach and view what it is we deliver. And I think a big shift in that thinking really is sort of you look at law firms versus, say, the big accounting firms. And the big accounting firms years ago sort of shifted their mindset from we're delivering accounting services to we're delivering some services, but ultimately we're delivering outcomes, and we're delivering an outcome's a product. And I think, as Kate alluded to, some of these low-level tasks are being commoditized. And, by commoditizing something, you're essentially making it a product. And you've got to look at it from a client's perspective. What are they paying you for, and what do they perceive the value to be, and what is that? And are there ways where, we can take a step back from our day-to-day, role as service providers to say, what at the end of the day, 1,000-foot view, do my clients want from me? What are they looking for me to deliver? And in some cases, that's just, an agreement. They just want this subscription agreement. They just want a shareholders agreement. They're viewing that as a product. It's a commodity to them, and they're going to pay X amount for what that product is. In other cases, it's a service. It's that 12 minutes of advice that saves their client that's invaluable. And, I think we need to make that cultural shift in terms of how we view what we do and enable ourselves to sort of scale that. And technology is going to help solve some of those problems as things do get more commoditized. And but it's making that shift away from, my time spent on this is exactly as valuable as my time spent on this. From the client's perspective, they just don't see it that way.
I would add that the UK is kind of further ahead than the US. And I think it's all, as you say, about cost pressures. The UK suffered as much or more so than the US during the downturn, and they had to come up with as innovative solutions to the problems that they were seeing. I think the Legal Services Act obviously had a huge impact on other delivery models, and I think we still haven't seen the real impact of what that actually looks like. It's unfortunate I left. It's all very exciting there. But what I realised is that Canada is very much similar to the UK. We have a precedent-based legal system that I think, and so KM as a department has been in the UK for decades. I was part of the KM department at Freshfields a long time ago, and I think there's something about the relationships that lawyers in Canada and the UK make. I find that they prefer to pick up the phone to another expert. The US, I think, are a bit more self-sufficient and would prefer to buy a piece of technology. They're a bit more geeky anyway, and would prefer to figure it out themselves. And I, again, love generalizations, which I've just made, sweeping ones. But largely, I think that there is something about the fact that, and I don't know whether it's risk averse. I absolutely find that Canadians and Canadian companies are a little more hesitant and don't boldly go anywhere, but versus the US. But I do think that there's that what happens in the UK, Canada follows. I mean, ultimately, we will be where the UK is. The Legal Services Act, like things, where we open up some of our legal profession and the changes that I think need to happen in legal education. I think some of these changes will happen, and we will be, and all of that will slowly change. I think. But they've just moved there faster because of the cost pressures from clients. But these clients are now global, and now we have to respond to global clients who are getting services in the UK and the US that they now are expecting from us, regardless of how small or large our firms are.
I'd just add that part of what motivated me to start Veritas litigation support a few years ago was my own experience as a litigator, but also I looked to the US, and there's a number of firms that have been around for a decade or more that are focused on providing trial support, particularly for jury trials, and demonstrative evidence aids. They came at it from more storyboards and graphics. I ended up coming into it more through the drone and have expanded it to include animations and other things. And then I realized through my research that there was no firm in Canada providing demonstrative evidence aids to lawyers, and that's what encouraged me to sort of take the risk and invest the time. And it all comes back to, in my view, helping manage litigation risk. Because if you can remove that scenario where the judge writes the decision and you go, oh, they didn't get it, that reduces risk. It goes, and clients are expecting that. They're expecting you to take all the steps you can as their lawyer to achieve a positive outcome for their litigation. So my experience is in the field of demonstrative evidence and trial support, the Americans have been much further ahead of us. We're I feel like I'm a homesteader in 1897 here in Alberta.
So speaking as a student who went into an office this summer and was tasked with various, due diligence and document review and whatnot, there was often times when I was told to do something away, and almost immediately after an hour or so of doing it, it was pretty clear that there might be a better, faster way of doing something. So I'm wondering if you guys are, finding that students or young lawyers are coming up to you with, new ideas, and if those are being implemented effectively.
No. I don't get it. I do not get it. I don't understand why they don't. Why they're not. It's like, why am I doing this? Really? I did all of that law school to do that? But we train all of the students in closing folders, in Kira, in XREF, all of the things that take some of that pain away. And we get a couple of people, oh, I'll do that. But they're playing at the edges. And I think some of it is, no, I don't really understand it. But maybe some of it's that hierarchy that they are told what to do. Like the person that instructs you doesn't use those tools because it's all so new, and so they think this is the only way to do it. And one of the tacts that me and my team are attempting is to get them to use these tools, get the students to use these tools for themselves. Not because they're part of a team, not because they're asked to, but because if you use these tools, you are more organized, you are more prepared than anyone in the team. And it doesn't matter if anyone knows that you're using it. So kind of guerrilla PKM, where we're trying to just encourage experimentation, I guess, is what it is. But, we don't, KM is a separate unit, and so it's difficult with the students who are, at the coalface and doing this one thing, because you must have been asked, you just do this one thing. You don't necessarily know that it's part of this massive, bigger deal, and that if you use this technology, it might screw up something else. Like, there's not enough of the context setting of the deal that you're in to figure out, well, so if I use this tool, is that going to be okay, or is someone going to shout at me? So what we've tried to do is we've set up these new training, substantive training workshops where we've got these big process maps. So we have 11, 12 of them now in different matter types, but. So we took private M&A, because that's easy. So we took a private M&A, seller and buy side, and it kind of describes the entire process. It's quite shocking seeing partners for the first time see that what they do is a process that starts at A and ends in Z and sometimes goes back to W. But for students, it's brilliant, right? Because they can see where the due diligence piece fits with everything else that's going on with the team, why everyone else is really, really busy on other things, and how the closing mechanics piece fits in and why it's so important. And I think that context setting is incredibly useful. But no, I don't get students, coming up to my office and saying, so, can I use this stuff? We have to actually inform them and tell them what's available. And some of that, not to go on, sorry, but I think some of that CPD stuff still has to change internally. The idea that we throw lawyers in the deep end and just get them to do document review as if that's a really good way of training lawyers today, I think has to end. But that leap from where we are of just, go and do that, versus constant feedback and getting them to do very different things and explaining the process and why is not done centrally. It's done, so you're lucky if you get a great partner who does describe it all, or senior associates that do describe why you're doing what you're doing. But I kind of want that piece to end so that we can kind of raise all the boats in the harbour and say, actually, this process, and there are different pieces along the way that can make you into a better lawyer than document review or creating lease summaries and copying and pasting from one Word document to another. And I'm so sorry that students have to go through that.
So I think we've got time for one more quick question here. think we've got one in the back.
My question is to the panel. Everybody's talking about decreasing rates, efficiency, and all that sort of stuff. I take the contra view. What you're working on right now has got to produce more money. Hello? I've worked on files where a little bit of thought beat the computer because we're smarter than computers. And the other side thanked us because it generated another 7 million, well, about a lot of figures for the lawyers working on the bank side, okay? How can this technology change be used to produce more income? Like, take a look at Microsoft. They're now getting us with the 365 on a subscription basis. How can you take this great idea here of being more efficient using technology and making more money for all of us?
Yeah, I mean, I think that's hits the nail on the head with a lot of the challenges with adoption. And when I'm talking to tech startups who come in and they say, you know, I've got this great idea to make the practice of law more efficient, and we're going to sell this to law firms, and you know, we're going to charge X for it, and I look at them and say, no law firm is going to buy this because you're taking away something that they make money on now, and instead you're going to charge them money to do that for them. So there is, you know, a significant amount of tension there. I think ultimately what it goes to, where some of this efficiency can lead to increased revenues, is in taking that more commoditized view and looking at, you know, certain aspects of what we do from more of a product basis. You can increase the volume of what you're doing. And if you're selling off sort of, you know, if you're doing more, say, the startup packages, if you can get that to a point where that's efficient and profitable, you grow a larger pool of potential, you know, clients who are going to grow into something, for one, but also if that's profitable on its own, you know, the less you have to touch that, and if that's a more automated system, you know, you start to generate, you know, revenues off of, you know, a different model. But I mean, it's a massive change away from the way people practice now, I think, to get to that sort of thing. But you know, that's part of the tension.
I take a contrary view. I think ultimately our prime directive as lawyers is to help people solve problems. And if we're better at solving problems, there'll be more people coming to our door, and they'll bring us bigger problems, and we'll be able to potentially charge more for our services. If I just want to prolong a litigation file to make more billable hours, it's pretty easy. I just got to tell the other lawyer he's fat and he's dumb, and he'll get mad and serve me with a notice of motion, and then I'll say, well, I got to cross-examine on your affidavit, and then, you know, and then we'll get some procedural ruling, and then I'll appeal the master's ruling to the Court of Queen's Bench, and we'll just party on. So my view is that at the end of the day, you know, I've got some disputes right now, and in other times and in other countries, the person who's aggrieved would not be calling me or you. They would grab a gun, or they would grab a horde of men, and they would go kill somebody. And so our jobs as lawyers is to help our society function well, and is not to make a lot of money. We make a lot of money because we help society function well. So I don't focus on the money, I focus on the result, and by focusing on the result, I've made a ton of money.
Okay, so we'll leave it at that so that everyone has time to grab some refreshments here before we hop into the next panel. We're going to break. If everyone could be back in and ready to go for 10:15, that would be great. We also wanted to thank everyone on the panel for joining us from both the Law and Business Association as well as the Faculty of Law. We appreciate you've come around from around the country to join us today, so thanks a lot. And if everyone could join me in thanking. Back for 10:15.